Committee will come to order. Rules Committee will come to order. We must ensure our financial system is helping the hardworking people in the middle. So today we are considering two bills to help balance the scales and protect and empower consumers. The first is H.R. 1815, which will ensure Americans get useful and understandable information they need to make smart investment decisions with their hard-earned savings. The second is H.R. 3624, which will shine a light on corporate outsourcing and provide more transparency for American jobs. These bills are about making sure our financial system works for those on Main Street, and I'm glad we're taking them up in the House this week. Now let me turn to our ranking member, Mr. Woodall, for any remarks he wishes to make.
Thank you, Mr. Chairman. It's a shared desire to fight for men and women on Main Street. There's no one I trust more on the Financial Services Committee than our ranking member to do that. I regret that we're not here today on bipartisan bills that we could move through the Senate and send to the President's desk to achieve exactly the goals that you and I share. But you don't need to hear that from me. We have our most able spokesman here, and I yield back to the witnesses.
Gentleman yields back, and I thank him for his opening. When the chairwoman gets here, we'll take her up after your statement, Mr. McHenry. So I'd like to welcome you to the Rules Committee, and with that, floor is yours.
Thank you, Mr. Chairman. And I want to thank the Rules Committee for allowing me to testify today and their openness to testimony from members. Committee Republicans are opposed to both H.R. 1815 and H.R. 3624, which is the subject of this meeting today. Neither bill helps the everyday investor, including retail investors, make better choices. Neither bill helps create greater investment opportunities or increased capital access for everyday investors. Neither bill strengthens our public markets, the markets that families rely on for their retirement, college for their kids, or just to achieve a better life. The bills are more of the same: more partisanship, more mandates, more bureaucracy. H.R. 1815 is an overt attempt to undo the Securities and Exchange Commission's rulemaking package on regulation best interest and Form CRS. The bill forces the SEC to conduct investor testing on a regulation that the SEC has already adopted and one that makes significant improvements for everyday retail investors. In fact, the SEC has already conducted investor testing on this rulemaking. The SEC conducted a nationwide survey and conducted one-on-one interviews with retail investors. In addition to the survey and in-person interviews, the SEC conducted 7 retail investor roundtables and received more than 6,000 comment letters. The SEC has the information it needed at the time to adopt a workable and usable Regulation BI and Form CRS, all without H.R. 1815, the bill before us today. In short, the rulemaking package on Regulation BI and Form CRS finalized by the SEC raises the standard of care owed by broker-dealers to retail investors. That matters, and that is a good thing. But my friends on the other side of the aisle didn't like the SEC's thoughtful, information-driven outcome. So they introduced H.R. 1815. H.R. 1815 ties the SEC's hands in 3 ways. 1, it requires the SEC to conduct investor testing on all future rulemakings, which they already have pledged to do in their rulemaking to date. It requires the SEC to conduct investor testing on past rulemakings that have been finalized. And finally, the bill creates a bureaucratic loop that requires the SEC to conduct investor testing on any rulemaking of which previously untested substantial changes have been made. So what I'd focus on for the purposes of this hearing are changes that we found that is the bill before us today, not the bill we reported out of committee. There are substantial changes to these. These are not minor technical changes routinely authorized at the conclusion of a markup. The Rules Committee print before us today that you're considering is dramatically different than the bill that was reported out of the Financial Services Committee. I know it's not unprecedented, but I do believe it is noteworthy. For example, investor testing is now required for disclosure rulemaking when documents or information, quote, are required to be delivered to and are intended or substantially likely to be materially relied upon by a retail investor. That term of art does not exist in existing securities law. We have not dealt with that subject matter in our committee jurisdiction. We're not sure what it means. The Securities Exchange Commission will have to figure out what that means and write rulemaking around that piece of this bill, if passed into law. And there's an entire new section on the rulemaking, on the rules of construction for this bill. There's a new and expanded role for the investor advocate. The list goes on. The full committee did not consider the bill that we are considering tonight, and I want to note that for the record. My Democratic friends might say the changes narrow the bill's reach and Republicans should support it, but we don't know that because we didn't have a hearing. This wasn't brought up at the markup, and the changes before us are just my conjecture based off the legislative text. And for these reasons, I oppose H.R. 1850. I'll be more brief about H.R. 3624. The bill adds yet another reporting requirement to the already vast list of information public companies must disclose. Mandated disclosures like H.R. 3624 only add to a company's cost of compliance. Companies already provide information on risk exposure, material financial data, and the company's financial condition. These reports help investors determine whether they believe in the company's value and that value is worthy of the investment. During the hearing on this bill, witnesses shared that just knowing a percentage of a company's workforce resides in a particular state or abroad is not particularly helpful. It doesn't tell you whether employees are working remotely, because that's where they want to be, if there's sort of flex work arrangement in a business. It doesn't tell you working remotely is actually better for work-life balance, as we've discussed, and for federal workers and across the marketplace. It doesn't tell an investor whether an employee working abroad moved for work, whether specific expertise is required that is central to that job, and otherwise cannot be found in the United States, or whether moving jobs overseas resulted in cheaper products to the American consumer or more expensive products to the American consumer. We simply do not know. Thus, the information sought by H.R. 3624 at best tells an incomplete story and at worst could be deeply misleading. One can only conclude that the purpose of this bill is to use the information to try to shame public companies based on incomplete and misleading information. And for this reason, I oppose H.R. 3624. I'm happy to answer any questions, and I thank you for inviting me to testify.
Thank you, gentlemen, for his testimony, and appreciate him going first. I'd now turn to the Chairwoman of Financial Services, Ms. Waters, for her testimony.
Thank you, Chairman Perlmutter, Ranking Member Cole, and members of the committee for having me here to testify on H.R. 1815 and H.R. 3624, two pro-investor pieces of legislation crafted with the input of investors, industry participants, consumer advocates, and labor representatives. These bills are being brought forward by two of our new members on the Financial Services Committee, Representative Caston and Representative Axney. H.R. 1815, the SEC Disclosure Effectiveness Testing Act, would simply require the Securities and Exchange Commission to test its documents with retail investors through one-on-one interviews and surveys to ensure that disclosure documents intended for retail investors are actually understood by their targeted audience. The SEC's approach to protecting retail investors from conflicts of interest and other risk has been based on informing them through disclosure. This is a problem when retail investors don't understand those disclosures. Since at least 2012, when the SEC conducted its financial literacy study, we have known that many of the disclosures intended for retail investors are not well understood by those investors. And while the public has the opportunity to comment on most rulemakings on any new disclosure, these comments are largely from well-funded industry representatives rather than the mom-and-pop investors that will be receiving these new disclosures. H.R. 1815 ensures that the SEC gets the input it needs from retail investors on disclosure forms by requiring the SEC to test those forms and engage in qualitative one-on-one interviews and nationwide surveys. This bill promotes common sense, evidence-based rulemaking and ensures that investors have the protections of the disclosures as intended, and that industry isn't just providing outdated and unused documents. For that reason, investor testing has been embraced by both Democratic and Republican commissioners at the SEC. In addition, the SEC itself has engaged in investor testing in several instances, including most recently in 2018 of a proposed disclosure for brokers and investment advisors to provide to retail investors known as Form Client Relationship Summaries, or CRS. This proposed 5-page disclosure was intended to help retail investors understand the obligations owed and services provided by investment professionals, as well as the fees and costs that would affect their investment accounts. To ensure that retail investors were able to use Form CRS as intended, the SEC conducted a nationwide online survey of 1,800 individuals and 31 qualitative, in-depth interviews in Denver and Pittsburgh. The mixed results of the SEC's testings of Form CRS showed that changes were in order and potentially more testing. Unfortunately, the SEC did not engage in robust, interactive investor testing that H.R. 1815 would require and finalize a vague disclosure. H.R. 1815 would require the SEC to engage in retrospective review and testing of existing disclosures like Form CRS and determine whether substantive changes should be made. This review of existing documents is particularly important as the capital markets, investor behaviors, and investing trends change. I would also point out that other regulators like the Consumer Financial Protection Bureau and the Federal Trade Commission have also engaged in usability testing of their disclosures. H.R. 1815 simply builds on the existing efforts of the SEC by requiring the Commission to engage in a similar interactive process for any existing or future disclosure intended to help retail investors make investment decisions. I note that I have filed a manager's amendment that makes certain technical modifications to the Rules Committee print, and I would ask the committee to make that in order. Again, I thank Representative Costin for creating this common-sense piece of legislation that will help investors make better financial decisions regarding their hard-earned savings. Turning to H.R. 3624, the Outstanding Accountability Act of 2019 would protect American workers by shining light on companies that are shipping jobs overseas. Although public employees are required to disclose their total number of employees, there is no requirement that they disclose where those employees are geographically based. This allows companies to quietly ship jobs overseas and makes it difficult for investors to know if the companies they're invested in are creating and protecting American jobs. Moreover, voluntary outsourcing data disclosure has declined in recent decades. According to AFL-CIO, multinational companies have increasingly focused job creation in non-U.S. markets and would prefer not to disclose numbers that could lead to reputational risk. By requiring companies to disclose the locations of their workforce, the Outstanding Accountability Act would provide investors with the critical information they need to invest in companies that are investing in the American economy and will incentivize companies to invest in American workers. So I urge this committee to advance H.R. 1815 and H.R. 3624 to the House floor and request the committee to provide an appropriate rule for its consideration. I'm happy to answer any questions that you may have. I yield back.
I thank Chairwoman Waters for her testimony, Ranking Member McHenry for his testimony, and I turn to Mr. Hastings for any questions he may have.
I thank the witness for being here. I have no questions, Mr. Chair.
I now ask Mr. Woodall if he has any questions.
Thank you, Mr. Chairman. Just one, the committee made an effort earlier this year to make sure that bills coming before the committee had hearings and markups. And I think that's been a very productive change that the new majority has made. It only becomes more complicated when there are dramatic changes in a Rules Committee print. And I heard that from the testimony of the ranking member as well as from you, Madam Chair. Could you tell me a little bit about the changes that were made between the committee markup and the Rules Committee print and why those changes were
The
necessary.
changes that are anticipated are actually, these changes reflect concerns by the Republicans that the bill was overly broad by narrowing it to exclude documents that aren't intended for or primarily used by retail investors, including Form 10Ks. So it's something that we work with the Republicans on.
Well, that is always something I like to hear. Is that right, Mr. McHenry?
That's news to me.
These were partnership
That's
changes?
news to me.
I'm sorry?
That's not correct. Republicans had critiques during the markup. We offered amendments, and the bill before us is not something that we've seen. From what was reported out of committee to what we're dealing with is the rules print. Now, the Rules Committee does have this authority to change what bill goes to the floor. I recognize that, but these were not changes that were negotiated by the two parties to make this a bipartisan bill. We had constructive amendments that we offered to say, if this is an interest on a going forward basis, that's fine. And so those critiques that we offered in the markup were about the failures of this bill. And I'm just being alerted, I'm being reminded that we didn't offer any amendments to this bill. We had critiques for it, but it was so deeply flawed in the legislative drafting that once you put a bill into investor testing and you took the information and altered any bit of the existing rule, you'd then have to put that new rule out for investor testing. And if that resulted in any changes, again, you'd have to put it back out for investor testing. So we don't know the cost of that for the Securities Exchange Commission. We don't know the cost on a going forward basis, much less what it would do to the existing regulations that are very important for investor protections that the Securities and Exchange Commission currently has.
I think the.
Will the gentleman yield?
The chairwoman's recognized.
I would like Mr. McHenry to address whether or not the changes that we have made will address the concerns that they identified. The staff my staff sought Republican staff input following the markup and shared this exact text in the spring. So having said that, he had some concerns. I think he will agree that we've attempted to address those concerns, and I would like to know whether or not what we have done reflects the concerns that they identified.
Mr. McHenry.
Sure. I mean, what I would say is you've addressed in part some of those concerns. The legislative drafting here of the underlying bill is so deeply flawed, that's the reason why we decided to not offer amendments.
Oh, I see.
During the markup. We did have critiques, but what we have before us is a wholly different product out of the committee based off, I think, some of those critiques. Not all of them, because you still have the failure of this bill that once you have any change that comes from investor testing, that you have to go back out for more investor testing. That's one. And it still appears to apply to existing regulations that the Securities and Exchange Commission has on the books. I think that's a failure of drafting rather than the will. What we saw during the markup is that this was an attempt to undo Reg BI and Form CRS, which was at the heart of the DOL fiduciary battles that we had between the two parties for a number of years. That the SEC, I think, has attempted to come to some remedy on. And this bill, I think, is focused on undoing Reg BI and Form CRS. And if that's the case, then that's the reason why Republicans wouldn't support any sort of look back for existing regs in part.
Mr.
Will the
Woodall,
gentleman
you
yield?
had yielded back, but since there have been some additional answers during your questions, do you have any other questions?
No, Mr. Chairman, but I would like to point out that when this debate is published, it could well be published by one of our former Rules Committee staffers, as the President put forward Hugh Halpern's name to be the Director of the Government Publishing Office today. And so those who have wondered what can become of you when Rules Committee staffing work is over, you too may one day
God bless you.
for that. But I thought that was
right.
a
Gentle-
tribute. As you know, Hugh served this committee for many, many years, and I just wanted to share that with
We
folks.
should congratulate him, and the gentleman has yielded back.
I will yield back.
Okay. Mr. Raskin, any questions?
I've got no questions, Mr. Chairman. I just want to thank Mr. Woodall for those very positive remarks he made about our commitment to trying to have hearings and markups before bringing forward, and I feel strongly about that too, and I think it's really bad.
Mr. Burgess, do you have any questions? Ms. Scanlon? Gentlelady from Arizona, Ms. Lesko, is recognized.
Thank you, Mr. Chairman. I do have a couple of questions. When I was reading this, Mr. McHenry, it seems like this rulemaking would actually improve, especially the best interest regulation, would improve what we have over the status quo. Is that correct?
I believe that's correct.
Okay, and from what I read, it looked like there was a lot of input, like 6,000 people made comments, they interviewed, I think the RAND Corporation, previous to the rule, did all kind of analysis, surveyed people, got one-on-one interviews with 31 people. And so, as you said, I really don't understand why we'd want to delay something that is actually better, an improvement than the status quo. I did also see that there was a letter in here, must have went through your committee, from the Insured Retirement Institute, that basically said, as currently drafted, the bill would place an extremely onerous and unnecessary mandate on all the Security and Exchange Commission's rulemakings by requiring investor testing of all disclosure documentation, and it would take away from what the Commission's normal duties are. Do you agree with that?
I agree, and as I said in my testimony, I believe that this is an intention. The intention here is to undo Rule Reg BI and Form CRS. And if that is, in fact, what the Congress wishes to do, then the Congress should have a straightforward bill to do that without the broad implication to every other piece of regulation the Securities and Exchange Commission has on the books, good or bad, looking back or on a going forward basis. I'm happy to work with the majority party so that we have a congressional mandated testing regime along with a cost-benefit analysis for regs at the Securities Exchange Commission and across the financial services jurisdiction as well. But this matter before us today is much broader in its negative impacts, I believe, for securities disclosures and retail investor disclosures, but has the definite impact of striking at Reg BI and Form CRS.
And thank you, and I oppose the bill. Thank you.
And gentlelady yields back. Gentleman from New York, Mr. Morelli, is recognized.
Thank you, Mr. Chairman. Madam Chair, what's the definition of a retail investor?
I beg your pardon?
What's the definition of a retail investor?
A retail investor would be described as one that is not representing like the pension funds for, a state or a city. These are like smaller investors that we're talking about.
And is there such a thing as a wholesale investor? Is that is there a term? Wholesale investor, is there such a term?
I don't know if such a term is used, such as wholesale investor, but I do know that retail investor is commonly used.
So for people that are professionals, the non-retail investors, what standard do they have? Do they use a similar standard or set of standards as is identified in this bill? So either best interest or
There are
fiduciary?
some protections for retail investors.
No, I'm talking about for professional, non-retail.
What about professionals? What is your question?
So what standard are they obligated to use? Do they use a best interest? Do they use a fiduciary? Is there just a whole different set of requirements?
Yeah, there is a different set of requirements, and you're talking about professionals who demonstrate that they have not only the wherewithal, but the resources that in the event that they do not come out on top, that they're winning, that they will not absolutely be devastated. The protection is for the retail investors who don't have the background, who don't have the resources. They're absolutely taking a chance, and there's some attempts to try and protect them.
So they're more sophisticated investors.
Less sophisticated investors are your retail investors.
Would Warren Buffett be a retail investor?
I don't think so, and you don't think so either.
No, I don't know what if it's,
Yeah.
I don't really know enough about this.
But certainly, he would not be.
And give me a sense of what the difference between the fiduciary standard and the best interest is.
We have had a lot of discussion over the years about fiduciary responsibility. That is, we have to look at what is in the best interest of the client, whether or not those who have the responsibility for advising, for making decisions, helping to make decisions, are doing it in the best interest of the client, or are they doing it in their own best interest where they're going to make more commissions, they're going to benefit from it.
So in defining fiduciary, you said in the best interest of the client. What is the best interest standard if that's not what
Well,
would that standard be?
The best interest of the client certainly has to do with whether or not the client is going to benefit from this investment in some reasonable way, or whether or not the client has absolutely no understanding about what they're getting into, and that if you are a senior, for example, that's being guided toward investments, knowing that you aren't going to live very long, and that investment will not benefit you, we're talking about those general kinds of considerations.
So what you just described is the fiduciary standard or the best interest standard?
Well, when I talk about fiduciary responsibilities, I'm talking about best interest also. Is it in the best interest of the client?
So how do you
To-
define
to-
best interest standard? Isn't that what this is essentially, the two different standards? No? Maybe I read the thing wrong then.
That's okay.
So what are the two standards then? Best interest, standard of conduct, right? And then isn't there a fiduciary?
Well, as I said,
that the difference here?
I consider fiduciary best interest synonymous.
Okay, so there's not two standards here that is being considered, two different standards? I thought that was the point of this, was to test to make sure that the two different standards.
If I might interject?
Yes.
I think it has to do with brokers on the one hand and investment advisors on the other hand.
Yeah, but
Not
it's
mistaken, but they're
intending
the
to.
same.
But yes, but I think there are two different standards. They want the broker dealers to have the standard, right, the same standard in place. But there are two different standards. There's a lower standard and a higher. I was just trying to understand what the difference was. Right? I mean, they want it, no, that's not right?
No.
So how would you describe that?
I have described the fiduciary standard, and that is the
Isn't this a higher standard that you're trying to
Well, no,
achieve for broker
fiduciary
dealers?
simply is basically described as you must act in the best interest of your client.
Right.
And that's the fiduciary requirement, as we have long discussed this in this Congress, whether or not that broker is acting in the best interest of the client rather than in him or herself. Are you worried about your commissions? Are you worried about making money rather than whether or not this investment will absolutely benefit or give a reasonable chance of benefit to the client that you are.
So there are two standards, there's fiduciary and suitability, I think. That's the way
I
you
don't
say
know.
that.
I don't know. All I know is fiduciary.
Okay, all right. Thank you, Mr. Chair.
Thank you.
Gentleman yields back. Gentlelady from Florida, Ms. Shalala? No questions. Gentleman from California? No questions. Does any other member of the committee wish to ask any other questions? Seeing none, I'd like to thank our witnesses for being here today. Please leave anything you would like inserted into the record with our stenographer, and you are now dismissed. Our Are there any other members who wish to testify on H.R. 1815 or H.R. 3624? Seeing none, this closes the hearing on those measures. At this time, the chair will entertain a motion from the distinguished gentleman, gentleman from Florida, you, Mr. Hastings.
Mr.
Gentleman's
Chairman,
recognized.
Mr. Chairman, I move the committee grant H.R. 1815, the SEC Disclosure Effectiveness Testing Act, a structured rule. The rule provides 1 hour of general debate on the bill, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 116-34, modified by the amendment printed in Part A of the Rules Committee Report, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes in order only those further amendments printed in Part B of the Rules Committee Report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in Part B of the report. The rule provides one motion to recommit with or without instructions. The rule provides for consideration of H.R. 3624, the Outsourcing Accountability Act of 2019, under a structured rule. The rule provides 1 hour of general debate on the bill, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill, and the rule makes in order as original text for the purpose of amendment, the amendment in the nature of a substitute recommended by the Committee on Financial Services, now printed in the bill, and provides that it should be considered as read. The rule waives all points of order against that amendment in the nature of a substitute, and the rule makes in order only those further amendments printed in Part C of the Rules Committee report accompanying the resolution. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debated for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in Part C of the report, and the rule provides one motion to recommit with or without instructions.
You've heard the motion from the gentleman from Florida. Is there any amendment or discussion?
Mr. Chairman?
Gentleman from Oklahoma is recognized.
Thank you very much, Mr. Chairman. Mr. Chairman, I have an amendment to the rule. I move that the committee provide an open rule for H.R. 1815 and H.R. 3624. It's not like we have a heavy schedule this week. We're not going to be doing a lot. These are the only two pieces of legislation on the floor, so I think it's an ample opportunity for us to actually let everybody participate in the legislative process, and if they've got an idea, offer it up. So with that, I yield back my time.
Gentleman yields back. We've heard the amendment from Mr. Cole. Is there any other discussion on his amendment? Seeing none, the vote is on the gentleman's amendment. All those in favor signify by saying aye. Aye. All those opposed, no? No. Noes have it. Gentleman has requested a recorded vote. The clerk will please call the roll.
Mr. Hastings?
No.
Mr. Hastings, no. Mrs. Torres? Mr. Askin? Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. McGovern? Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Aye. Mr. Burgess, aye. Mrs. Lesko? Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 6 nays.
The the amendment is not agreed to. Is there any other amendment or discussion?
Mr. Chairman?
Mr. Woodall is recognized.
Thank you, Mr. Chairman. I have an amendment to the rule and move that the committee add a section to the rule that provides that it shall be in order at any time through October 31st, 2019, for the Speaker to entertain motions that the House suspend the rules relating to the bill H.R. 553 to amend Title 10 of the United States Code to repeal the requirement for reduction in survivor benefit annuities under the survivor benefit plan for military spouses. You will recall that it's been, at the end of this week, 100 days since the House passed the NDAA, and this committee, in its wisdom, decided to roll Mr. Wilson's bill that had qualified for, again, another new change that the new majority made that was a very powerful and productive change, the consent calendar. And Mr. Wilson's bill, because it had been produced in such a bipartisan way and he'd garnered so much support, qualified to be considered under the consent calendar. Because this committee decided to roll the bill into what was the single most partisan NDAA in my adult lifetime, the Wilson language, again, that's almost unanimously agreed to by members on this committee, continues to languish in the United States Senate. If you make my motion a part of the rule, Mr. Wilson will get that vote. I know the chairman has been, no one has worked harder than the chairman to make this possible for these survivors to access benefits that their loved ones have earned. 100 days is too long for this bill that this Congress has found so much bipartisan agreement on to continue to languish, and so I ask my friends to support this. It won't do anything controversial. It will simply allow a floor vote, again, as Mr. Coles pointed out, on a very light floor week on a bill that we all agree to and that will make a big difference in people's lives. I thank you, Mr. Chairman.
All right, gentleman yields back. I just say to my friend, it's in the NDAA, and I would suggest to my friend that he go talk to some of his friends in the United States Senate. We've heard the motion. Is there any other discussion? Seeing none, the vote is on the gentleman's amendment. All those in favor signify by saying aye.
Aye.
All those opposed, no. No. The no, in the opinion of the chair, the noes have it.
Mr. Chairman, can I ask for a recorded vote?
Gentleman's asked for a recorded vote. The clerk will now read the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? Mr. Raskin? Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? No. Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. McGovern? Mr. Cole?
Aye.
Mr. Cole, aye. Mr. Woodall?
Aye.
Mr. Woodall, aye. Mr. Burgess? Aye. Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 6 nays.
That is defeated. The amendment is not agreed to. Is there any other amendment or discussion? Mr. Burgess is recognized.
Thank you, Mr. Chairman. I have an amendment to the rule to make an order and provide the necessary waivers to allow amendment number 2 to H.R. 1815, offered by Mr. Stivers of Ohio. This amendment adds climate change disclosures to the proposed rules and regulations that would be subjected to investor testing in the underlying bill. This will help retail investors understand how a business in which they are investing is dealing with the issue of climate change, and if and how those efforts would impact that investment. So I think it's an important amendment that Mr. Stivers has offered, and failing the granting of an open rule, which I believe Mr. Cole argued for very eloquently, this would be a good one to make in order. And as has been previously pointed out, we have plenty of time to debate.
We've heard the gentleman's amendment. Is there any other discussion? Seeing none, the vote is on the gentleman's amendment. All those in favor, please say aye.
Aye.
All those opposed, no. No. In the opinion of the chair, the noes have it.
Roll call, please.
Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? Mr. Raskin? Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. McGovern? Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess?
Aye.
Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 6 nays.
The amendment is not agreed to. Is there any other amendment or discussion? Gentlelady from Arizona is recognized.
Thank you, Mr. Chairman. I have an amendment to the rule to make an order amendment number 4 to H.R. 1815, offered by Mr. Emmer from Ohio. He's from Minnesota. I don't know why it says Ohio on this. This amendment applies the bill's investor testing to any disclosures relating to environmental, social, or governance factors. Mr. Chairman, similar to the amendment offered by Mr. Stivers, all this amendment seeks to do is require investor testing on environmental, social, or governance factors so investors can better understand how business efforts with regards to these factors impact the investors. Again, this seems to be another priority of the Democratic majority that should also have the opportunity to be investor tested. Certainly, this important amendment deserves the opportunity to have a vote on the House floor and therefore should be made in order.
Gentlelady yields back. We've heard the gentlelady's motion. Is there any other discussion? Seeing none, the vote is on Ms. Lesko's amendment. All those in favor, please say aye. Aye. All those opposed, please say no. 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 In the opinion of the chair, the noes have it. I'm very enthusiastic. Gentlelady's asked for a roll call vote. The clerk will please call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? Mr. Askin? Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? No. Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. McGovern? Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Aye. Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 6 nays.
The amendment is not agreed to. Is there any other amendment or discussion? Seeing none, the question is now on the motion offered by the gentleman from Florida, Mr. Hastings. All those in favor, please say aye. Aye. All those opposed, no? No. In the opinion of the chair, the ayes have it, and the motion is agreed to. Mr. Cole has asked for a recorded vote. The clerk will please call the roll.
Mr. Hastings? Aye. Mr. Hastings, aye. Mrs. Torres? Mr. Askin? Ms. Scanlon? Ms. Scanlon, aye. Mr. Morelli? Aye. Mr. Morelli, aye. Ms. Shalala? Aye. Ms. Shalala, aye. Mr. DeSaulnier? Mr. DeSaulnier, aye. Mr. McGovern? Mr. Cole? No. Mr. Cole, no. Mr. Woodall? No. Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mrs. Lesko? Mrs. Lesko, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk will report the total.
6 yeas, 4 nays.
The ayes have it, and the motion is agreed to. Accordingly, the gentleman from California, Mr. DeSaulnier, will manage for the majority.
And the gentleman from Georgia, Mr. Woodall, will manage for the Republican.
Without objection, the committee is adjourned.